I'm Rob Tracinski. This is Symposium, where we talk about the ideas at the basis of a free society. My guest today is Peter Shane, who's a distinguished scholar in residence at the law school at New York University. And he wrote an article arguing against the unitary executive theory for the regulatory review, which as part of my work for the Unpopulists, we helped adapt that for the Unpopulists. And that's what I wanted to talk to him today about primarily. So thanks for coming on, Peter.
Oh, Rob, it's great to be speaking with you.
And so, well, first of all, let's start with unitary executive theory and then go to some of the issues that connect to that. So what is the unitary executive theory and what's the supposed constitutional basis for it?
Sure. So what has come to be called the unitary executive theory, I suppose, has some different flavors to it. It used to be just a fight about whether the President of the United States was constitutionally guaranteed a power to remove at will basically any subordinate in the executive branch. It is morphed into something yet more extreme, which is an idea that the Roberts Court has seemingly embraced a couple of times, although basically in dicta, that the President of the United States is a one-person branch of government. And pursuant to this theory, the agencies of the executive branch are just there to assist the president in executing the law, that they are not instruments of Congress, they're somehow instruments of the executive. The basis for it, the assertion is really twofold. One is that something in the text of Article 2, maybe the vesting clause that vests the executive power in a president of the United States, somehow conveyed a little one version of unitary executive theory or another into the presidency. Or it may be that the responsibility to take care that the laws be faithfully executed implies that the president has either the removal power or some bigger stretch of power. And then the second idea, I guess, behind it is that this was somehow endorsed at the time of the framing of the Constitution. That this is the Constitution properly understood as of 1789.
Right. So I want to talk about the removal power. So this is you can fire basically any government worker. And this is something that has come up in a couple of current cases with having to do with heads of the FTC, heads of several other executive agencies, where Congress created a law saying these people cannot be fired except with good cause. So basically you have to get some specific malfeasance, bribery, incompetence, diminished capacity. You have to get some very specific reason why you're firing this person. And the claim now being made is no, the president can fire them for any reason, just because he doesn't like them.
Correct. So again, and this gets very weedsy very quickly. Mm-hmm. So the fights have generally been over the president's responsibilities or his authority over what we call the principal officers of an agency, the heads of the agency. Now, a multi-member commission like the National Labor Relations Board has multiple heads. They're all considered the head of the agency. They're all the principal officer. It's not just the chair who's the principal officer, but it's also, the Secretary of State, the Secretary of Labor, what have you. The reason I say that this is primarily what the fight is about is that there's now an effort going on by the Trump administration to expand the president's ability basically to fire any so-called inferior officer or employee of the United States, notwithstanding the civil service law. And this is a kind of a separate subject. And it's interesting that in a 1926 case called Myers versus United States, which is Chief Justice Taft's embrace of the removal power in a very particular context we can get into. But in that case, he made clear he wasn't talking about the civil service, that if Congress made the decision that employees or inferior officers of the United States were to be appointed by somebody other than the president, which the Constitution allows, like, inferior officers in the Department of Homeland Security can be appointed if Congress wants this to happen by the Secretary of Homeland Security. They don't have to be appointed by the president. And what Chief Justice Taft said, even in this opinion that embraced, it's considered the kind of seminal text for unitary executive theory, he said, if Congress does this, if Congress vests the appointments power in somebody other than the president, they can limit removal. They can limit removability to good cause. Now, the fight over that's erupting over these multiple firings, and it's funny. So you mentioned that the essay I did for the Unpopulist was a reworking of something I'd written earlier. And of course, between version 1 and version 2, there were additional firings of principal officers, heads of agencies, and that you, as editor, suggested I add into the opening paragraph, which I did. And since then, there have been more. So
it's very hard to keep up these days.
It's very hard to keep up. So now he's fired members of the Consumer Product Safety Commission, for example, which is another independent agency. So Congress, okay, so to set the stage, the Supreme Court in 1926 decides that, and this was a controversial issue at the founding, that the Senate cannot participate in the removal of officers other than by impeachment. Congress had passed a law that said if the president wants to fire somebody who had been appointed with advice and consent, they could only be fired with the Senate's advice and consent. And Taft said that that was unconstitutional, and he embraced this idea of how important presidential removal power was to the faithful execution of the laws. But again, the only issue in that case was whether the Senate could participate. It really wasn't about the conditions surrounding the president, what he could do unilaterally. Fast forward 9 years. We get a case called Humphrey's Executor versus United States. Humphrey had been a Hoover-appointed member of the Federal Trade Commission. Federal Trade Commission, created in 1914, said nobody can be fired except for inefficiency, neglect, malfeasance, or neglect of office. And but Roosevelt fires Humphrey, who subsequently dies, which is why it's Humphrey's Executor. It's a suit over back pay. And he says, Mr. Humphrey, you're a great guy, but I'd rather have people on the commission who are of my mind when it comes to economic regulation, so you're fired. This is what the court had to decide first, was this in violation of the statute, and if so, was the statute constitutional? And they answered yes to both questions. That is, they said the fact that the president doesn't agree with you is not inefficiency, malfeasance, or neglect of office. And Congress has the authority to protect the tenure of members of these multi-member commissions. Why? Well, we'll get into that in a moment. But the thing that's interesting about Humphrey's Executor is that they reached this conclusion unanimously. We had 9 members of the court representing champions of the New Deal, opponents of the New Deal, all for so-called horsemen of the apocalypse who were opposed to New Deal reforms, but also Cardozo and Brandeis, the leading liberals of their era, all united around a single opinion that said this was constitutional. The Roberts Court is enamored of some version of unitary executive theory. And in a case they decided called Sela Law, they said Humphrey's Executor does not apply to single-headed agencies. If an agency is directed by one individual, then the president, according to the Roberts Court, is constitutionally guaranteed the right to remove that person at will. I think that's wrong, but in any event, that's the law at the moment. And the court said, we're putting aside the actual question decided in Humphrey's Executor, which is whether this applies to multi-member agencies. And that's what the Trump administration now wants to test. They want to see whether the Roberts Court will go all the way and overrule Humphrey's Executor and allow the president to fire even the heads of multi-member agencies like the National Labor Relations Board, Consumer Product Safety Commission, and so on.
Now, I want to go back a little bit to look at this issue of why this is important, what the implication of this is, because the ability to be able to have people protected from being fired for political reasons. That obviously functions as a limitation on the president's power, right? So it's sort of a protection against the president's abuse of his power. And
Right.
we can see that with I don't think it's come up with the FCC yet, but there has been some, Trump has made some rumblings about having Brendan Carr, who's the current chairman of the FCC, having him prosecute people he doesn't like for, he saw some reports on 60 Minutes that he thought were unfair, and he wants CBS prosecuted or fined for that. And so the question, the FCC has another one of these multi-member boards, whereby I don't know if it's by law or by custom, the members of the board are bipartisan. There's a certain number of Democrats, certain number of Republicans, and that's sort of meant to be a protection against the abuse of power, that you can't just have somebody do your political bidding because there are other members on the board who are not dependent on you, who are independent. So that this is an attempt to sort of create, we have agencies created with a certain kind of power to regulate, and there's an attempt to limit that power and keep it from being directly politicized.
That's correct. So the provisions that you're referring to, which are typically a requirement that no more than a bare majority of the commission may belong to the same political party. So if it's 5 commissioners, no more than 3 can be Democrats or Republicans. If it's a 7-member group, no more than 4. And yes, so this is to further the idea that decisions will be made impartially and in almost a kind of quasi-adjudicative way, a more deliberative way, and less, just as a matter of pure presidential politics. Having said that, I think it's important to point out a few things. One is, whether Congress has created an agency to be independent or not is typically a matter of the politics of the moment. If you go through the list of independent agencies, you'll find some that you'll think, oh, okay, yes, I understand for like the stability of economic markets, it's important that the Fed be, a multi-member agency of the kind we're discussing. But why, for example, the Environmental Protection Agency is headed by a single person, but the Consumer Product Safety Commission is headed by multiple people, or the Food and Drug Administration is a single-headed agency, but the Federal Trade Commission is multi-member. This all has to do with, the politics of the given moment. And what's important, presidents have a significant influence over these so-called independent agencies. Almost every statute allows the president to designate who is the chair. It is by custom, not legally required, that the president pretty soon is going to be able to appoint that bare majority of his or her own party to the agency. And typically the chair, well, depending on the agency, the chair may actually have a lot of agenda setting power. So in something like the Federal Communications Commission, it's really the chair's show in a lot of respects. So one might say, okay, so what's the big deal? Well, the big deal is that the decision whether or not to have the agency be independent is a congressional decision. It's not a presidential decision. And Congress having made that decision, the president's job is to faithfully execute the laws. He may get his way. For all we know, the Federal Communications Commission is going to do something inappropriate with regard to going after some broadcast network that Trump doesn't like. But there will be dissents. There will be written dissents. And when that action is challenged in court, as it inevitably will be, that dissenting voice may be critical in how the court understands what the majority has done. And it's a real opportunity for members of the opposing party or an opposing point of view. Not every vote has to be on party lines, although they often are. But at least it allows the members of a group with an opposing view to offer really to a reviewing court what would be a different way of understanding what would be the the non-arbitrary, impartial way of having moved forward in a particular case.
And it also offers a warning to the public too. You have somebody on the inside who's able to say, "Look, this is happening, and here's why it's wrong." So it's a way of giving a warning to politicians and to the general public about some action that the commission is taking.
This is true, although, and I don't want to minimize the importance of that at all. Although, one of the reasons I think why American democracy is in a kind of precarious moment has been really the deterioration of the traditional press, really since 2000. Coverage of the federal government has not diminished quite as much as coverage of state governments. A scholar at Princeton named Paul Starr wrote once famously, "This is a great time to be a corrupt state official because the number of reporters who are devoted to genuine reporting on state house issues has dramatically shrunk." But when things go on in administrative agencies, it would be helpful if the public had a steady access to accessible prose explaining what's going on, how it affects their lives, and so forth. And that is not so easy to find all the time.
Yeah, yeah. So let's go to the constitutional issue here for the basis for the unitary executive theory. And this, they use the vesting clause as the big one. The executive power shall be vested in a president of the United States. Now, the interesting thing is you quoted Scalia on this, who says, they said that not some of the power, but all of the power is vested in the president. And the interesting thing is that the word "all" is not there in the vesting clause. It's not there in the Constitution. That's really kind of Scalia's addition. I want to talk about what's the evidence for a non-unitary executive in the Constitution. What are the parts that indicate that the executive isn't one piece? It's not a single person who is the executive agency.
Sure. So let me start by saying that there is something a little bit crazy about asking what ought the 21st century president's relationship to the 21st century bureaucracy be in light of what was George Washington's relationship to the government of 1789. Federal government of 1789 was about the size of our smallest cabinet department today. The civil service today is about the size of the population of the United States in 1789. So it's a little strange to think that we're bound by decisions that were made then. And I think what honest historians I think are most likely to conclude, looking at the 1789 period, is that the framers didn't start out with this very clear highly formal organization chart view of the separation of powers, in which they knew that presidents would be allowed to do powers A through M and Congress would do N through Z. They were inventing something new, especially with regard to the presidency. There was nothing like it before as a constitutional office. So attributing to them a fixed view of what the president should be is pretty likely to be historically inaccurate. Having said that, let me say, if you approach the Constitution in an open-minded way, that is, you were not determined to conclude that the president is the one-person branch of government, I don't think you would ever come up with that textual reading. And the reason I say that is as follows. First of all, with regard to the late Justice Scalia, we know that he's wrong about the vesting clause because Article 2 itself shares executive power with the Senate. It makes the Senate part and parcel of the appointments power. It makes the Senate part and parcel of the treaty approval power. These are concededly executive powers that are divided between the president and the Senate. Now, so someone of Scalia's bent might say, okay, well, that just means that the president is vested with all executive power that is not shared or regulated otherwise. Okay, fine. But then that only raises the question, is it shared otherwise? So let's continue reading in Article 2. Article 2 says the president has the authority to request the opinions in writing of the heads of departments with regard to the duties they have been assigned. I'm sorry, the heads of executive departments. Now, the fact that it says heads of executive departments makes it sound like the executive branch is contemplated as having somebody other than the president as part of that branch. It's right there, reference to executive departments, and they perform duties. Well, where are they getting these duties? Well, it can't just be from the president, because it would be absurd to say, not only does the president have the power to assign duties, he has the power to tell his subordinates, you have to let me know what you're doing in writing. I mean, that would be like the silliest provision in the world. The duties that the executive branch departments have been assigned are coming from Congress. And what the president is allowed to do is demand information from the departments with regard to how they are performing their congressionally, legally, statutorily assigned duties. And typically, again, this is sort of new for the president to have this power. But if you look at, and I'm indebted to a friend at Boston University named Jed Sugarman for pointing this out to me, the state constitutions prior to 1789 had this kind of, you can request information sorts of provisions, but typically from, the executive council could demand information of the legislature. But the implication was you could demand information from somebody because you couldn't remove them, but you were entitled to know what they were doing. So that's another clue. Now, okay, where are these executive departments going to come from? Well, that's up to Congress. Congress has the power under Article 1, Section 8 to create offices and departments. How do we know this? Well, if you're looking for the word all, here's where you find a mother lode of the word all in the so-called necessary and proper clause. This is the clause that allows Congress to make all laws necessary and proper for carrying into execution all powers vested by the Constitution in the government or in any department or officer thereof. And by department, I think the likely understanding is that means branch in that the way the word is being used there. So Congress gets to create these departments. And as long as the Congress is not undermining the president's ability to do the president's job, whether or not tenure protection is necessary and appropriate would be up to Congress. That's the most natural way of reading the text. And it is, I should say, the conventional way of reading the text prior to the Roberts Court.
Right, right. So one other thing I also found in this Article 2, Section 2, there's this intriguing little section. It says, what the Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. So it's creating this idea that Congress can make the decision as to who appoints people for not for the principal officers, but for the inferior officers, and indicates that the president may not be the person that they give that to. So there's another little element of a non-unitary executive just hanging out there in Article 2.
Oh, that's a very good point. And again, this goes back to Chief Justice Taft, who had, of course, been president. He writes the Myers case, 1926. This is the inspiration for the Roberts Court's view of the unitary executive. And he again reiterates a holding that the court had offered in the 1880s, that where Congress puts the appointments power in someone other than the president, Congress gets to decide on the conditions of removability.
Yeah, yeah. And so I want to talk a little bit more about the history of even the deeper history of this, going back before the Constitution, which is, because you could say, well, the world of 1789 was very different, but the world of 1789 and before 1789, they had dealt with a lot of the big problems that we're still dealing with today. And I'm intrigued at the role of, for example, English history. The English history is basically a long series of battles between the king and parliament, between the executive power and the legislative power. And the struggle was, how does the legislature control the king? And one of the ways they evolved was the idea that, well, the king has ministers. He's one man, but he has to carry out his actions through others. He has ministers whose job is to carry out these actions, and eventually we can have a say in appointing the ministers. And eventually they say, well, we're going to appoint the ministers, and we're going to appoint the prime minister who has really all of the power and take it away completely from the king. That's the parliamentary system that you eventually end up with. Where basically all the principal officers and the chief executive are all appointed by the legislature. Now, obviously, the founders did not choose to create a parliamentary system, but I think the advice and consent clause shows this idea of and that this reference, the way they reference the principal officers, it does show a leftover or that they are adopting some element of that view that Congress should have, the legislature should have some power over the appointments and over who are the people carrying out the tasks. And that the president just, can't just rule by edict. He has to go through these principal officers.
Absolutely. So at the time of the drafting of the Constitution, um, the framers, the founders were, reacting to the English experience and also to the experience of state governments between 1776 and 1787. And it is true that what they perceived, or what some of the framers perceived as overreaching by the state legislatures, influenced them in adopting a president who would have more independence from this new Congress than, say, the prime minister has from Parliament. But still, we're talking about an anti-monarchical zeitgeist, if you want, the spirit of the age, and the idea that because state legislatures had really made life kind of miserable for creditors in many cases, and were conducting trials that they should have left to the courts. That immediately said to the framers, "Oh, from now on, we want to go back to something like the all-powerful king," is just a complete fabrication. And the people, there are historians who support some version of unitary executive theory. Probably the most prominent books on the subject from that point of view are written by a fellow at the University of Virginia named Sai Prakash, who's, I want to say, a lovely guy, very serious scholar, and Michael McConnell at Stanford. And both of them sort of cast what Article 2 means in light of how much or how little of the kind of royalist tradition was being brought forward. Sai's book is called Imperial from the Beginning. And I think this, and again, I really owe a lot to another historian, Jed Sugarman, who I think is a much better cut on this, which is that this imagines a view of even the monarchy at the time that is much more absolute than history would support. Not only was Congress, Parliament having a role in appointments of ministers, but Parliament had created many offices that either were for terms of years that the king could not revoke, or even offices in which the office holder had a kind of property right that the king could not take away. And there were other limitations like this on the monarchs in Europe. So we imagine. So this idea that the vesting clause gives the new president all of the executive powers of the king typically comes with an imaginary view of what the executive powers of the king would have been in 1789. It just was a much more complicated picture.
Right, right. Now let's talk a little bit about the post-constitutional history, because you pointed out, I think you had a footnote or a link in the article about some early examples right after the Constitution. I think when they're creating the sinking fund to pay down the debt that the new federal government has taken on from the states, and they're appointing a commission to manage the sinking fund, and they appointed people on there who were not fireable by the president.
Right. Two members of the Sinking Fund Commission were the Chief Justice and the Vice President. neither of whom are removable at will. And by the way, I would just mention, the Roberts Court has created this, what I think is just an unsound, historically unfounded, highly formalistic, very rigid view of the separation of powers, which has invited, more and more legal challenges to the way in which various institutions of government are challenged. And there's been a lawsuit now challenging the constitutionality of the Judicial Conference of the United States, which is an administrative agency that has, certain responsibilities with regard to the judiciary. So the head of that agency is the Chief Justice of the United States. Again, for the plaintiffs in this case, are kind of a conservative public interest group that's trying to test the limits, I guess, of the Freedom of Information Act and the judiciary. If they won this case, you'd either have to conclude that the Chief Justice of the United States is removable at will, or that this thing has been operating constitutionally, even though it's part of the judicial branch and has been for decades.
Right. And you could also see the obvious problem with that, which is that, and I think this goes to the constitutional issue, one of the fundamental constitutional issues here, which is the Constitution has to be interpreted in such a way as to actually allow the big parts of it to function. And one of the big, so if you have, because there are certain executive functions that have to do with the administration of the judiciary. And if those executive functions are all part of the chief executive, all part of the powers of the presidency, you can see how that would basically eliminate the independence of the judiciary. That if Doge guys can go in there and cancel out the payments being made to judges or to other members of the court, if they could. If the president could basically take over the administration of the courts, decide who gets paid, decides who has a courtroom, who has an office, all of these administrative functions, you basically be destroying the independence of the judiciary.
Absolutely. And you I think quite correctly, used a phrase there that was very important in Humphrey's Executor, which upheld the constitutionality of the Federal Trade Commission. And it's often overlooked. You refer to executive functions. So the court in Humphrey's Executor spoke of executive functions and executive powers. Mm-hmm. And by executive powers, I think what they meant were those things that the Constitution placed explicitly with the president. I mean, nobody else issues pardons. That's an executive power. Nobody else is commander in chief. That's an executive power. Nobody else negotiates treaties. That's an executive power. But everybody in government, every institution of government has to hire staff, procure supplies, engage in plans, provide public contact information. As you say, this is routine administrative stuff. These are executive functions. And what the court in Humphrey's Executor said is, with regard to the Federal Trade Commission, and this is true of the independent agencies more generally, these executive functions are meant to assist in the discharge of authorities that the court called quasi-legislative and quasi-judicial. What it really meant is these are things that the executive branch only gets involved in because Congress created a statute that exercises its authority to implement the law in certain ways. Without the Federal Trade Commission or the Department of Justice, the president would have no role with regard to antitrust law. There's nothing in Article 2 that gives him an antitrust responsibility. So the court's saying, look, if Congress wants to set up an agency that is going to make judgments with regard to the implementation of antitrust law, then they get to decide how that agency is structured and the conditions for the removal of its directors, its commissioners. If we were talking about an agency to assist the president in negotiating treaties, well, that's a different story. And that's why, if you go back to that very first Congress, the president was given a lot of leeway with regard to how to set up what was originally called the Department of Foreign Affairs and the Department of War, because Congress said, look, there's Article 2 stuff mixed in here. But when it came to the Department of the Treasury, which only gets to do what it does because Congress is appropriating money, There you have a very detailed structure for the department, very specific assignments to people. And there's an instance, I guess, in 1819 when some war veteran is owed something by the Department of the Treasury, and they're not, and the clerk has made a judgment as to how much they're owed, and the president at the time thinks that's the wrong amount. Ask the attorney general, can I correct that? I mean, I think that's the wrong amount. And the attorney general says, and I'm supposed to take care that the laws be faithfully executed. And the attorney general says, your job is just to make sure that the person is faithfully executing the laws. It is not to execute the laws yourself. If you were to take over this decision and say this person gets $150, not $125, not only would you be going beyond taking care that others are faithfully executing the laws, you'd be breaking the law because you'd be doing a job that Congress had assigned to somebody else.
Yeah, it's an interesting example. Oh, and I, the constitutional history, I want to sort of mention, but mostly skip over one example before we get to where I think the real crux of this is. So, for example, one thing that fascinates me about this is that the removal power even wasn't somewhat in doubt up through the impeachment of Andrew Johnson, because one of the issues in the impeachment of Andrew Johnson, this is after Lincoln, right after the Civil War, that he had fired somebody. One of the cabinet members who Congress wanted to be, basically Congress wanted him in there because he would be tougher on Reconstruction. Johnson wanted somebody who would not be as tough on Reconstruction, and they tried to impeach him for firing this guy, for removing this guy. So the extent of the executive's removal power was kind of in question and in doubt as late as that. But to skip forward to, I think where this really comes up, because you can see this coming up. The issues we're dealing with now really come up starting with the Interstate Commerce Commission, and then especially with the FCC and the FTC, these things happening in the early 20th century. And this is really an attempt to deal with the idea that the government, the size of government is expanding and the power and regulatory reach of government is expanding. Congress wants government to be getting all sorts of new powers and being able to do new things for them. But at the same time, they're also trying to sort of limit and control that power through the law. And that's sort of the dilemma that they're facing.
Right. And again, it's easy to think, oh, the independent agencies, that this is sort of a problem because they're not as, if you're of this point of view, that they're not as controlled by the president as, the Unitarians want them to be. But with regard to the Federal Trade Commission, the Federal Communications Commission, started as the Federal Radio Commission, the ICC, the alternative available to Congress that they, were most familiar with was not setting up a non-independent executive agency. The question is, are we going to leave it to the courts? So, they could have left to federal courts the decision whether interstate rail rates were reasonable or not. They could have left to the courts a decision whether the charges that telecommunications providers were providing for, were imposing for radio service were proper or not. They could have left all of that to judges. So the question before them was not, it was not just how do we do this and not have the president interfere too much. It was how do we do this to make these decision-making processes more efficient so that, you don't have to go through the court system without giving up on some of the advantages of the court system, a formal record, a neutral decision maker, impartial decision making. And right now still, there's a lot of, speculation. What's the court going to do about Humphrey's executor? Are they going to go all the way? Trump is trying to give them a lot of opportunities to revisit this issue, and some of those cases are already making their way through the lower courts. What I think my colleagues conventionally think is a problem for the court is it would be very hard to say the president has complete removal power over the NLRB or the Federal Trade Commission or the Consumer Product Safety Commission, but the Fed gets to remain independent. And I think the court is very reluctant to claim for itself what might be the calamitous consequences of deciding that only the United States among post-industrial nations cannot put the regulation of the money supply in an independent agency. I mean, that would be an extreme position to take, and one that the stock market would not react well to.
Absolutely. Well, the interesting thing about that brings up something interesting, which is you mentioned that Humphrey's Humphrey's executor was considered a conservative solution at the time in a way, because, and this maybe has to do with the partisan politics at the time, because they were denying power to FDR, right? FDR wanted to be able to say, I can fire these people, and they were telling him no. So it was kind of viewed as more of as something that would limit the power of the president, which was viewed, being able to limit the power of the president was viewed as a conservative solution at the time. And I, as someone who hails generally from the right, I could see that there's a long tradition on the right of saying, yes, government power should be limited. The executive shouldn't be able to do everything he wants, as being. So how did this flip to becoming a Republican cause to say, oh, that we want an all-powerful executive?
I think that my own view of things, which is the subject of a book which I don't know if it's come out yet, by William Howell and Terry Moe, called Trajectories of Power, I think. They talk about what has happened really since the New Deal in terms of the politics of the presidency. And you're right, it is weird. I mean, there's a very fine libertarian scholar named Ilya Somin, Somin, who has said, it's weird to see libertarians arguing for so much presidential power. I mean, what are we doing? But here's the deal, as another president would like to say. Every president, and this is the Howell and Moe view of things, every president is motivated by wanting to make their mark on history. They want to be remembered as a great, impactful political actor. Now, from the 60s forward, Congress has reacted to various I would say, national needs or social movements calling for change, whether it's the consumer movement or the civil rights movement or the environmental movement or the women's movement. And all of these movements and all of the kind of politics around them yields legislation that authorizes the executive branch to do new things. And so progressive presidents, and I'm using the word progressive here very loosely, I mean, and under what I'm saying, Dwight Eisenhower would have been a progressive, Richard Nixon was a progressive. They want to be known in domestic affairs for having addressed big problems in an impactful way. They don't need new constitutional powers to do that. They just need the statutes that have been enacted. In some cases, they may go a little overboard in interpreting what the statutes mean, but that's an easy thing for courts to push back on. That's conventional administrative law stuff. What did that statute really mean? I'm a regulated party. I don't like it. I'm taking you to court. We'll have the court make a decision. So, a President Carter, a President Clinton, a President Obama, a President Biden, again, they may do things that people don't like, but almost invariably they are resting on a statute because Congress has passed statutes to get stuff done. From Reagan forward, if you are a Republican president, or I should say, and again, it's just, whether it's Republican or Democrat, really, that's just an accident of history. If you are an anti-administrative state president, you want to shrink what government does, then you don't have obvious statutory authority. And in 1980, it looked as if Republicans thought, I think, that their best chance of yanking the government into a more conservative direction would be by controlling the White House. And, they still believed what Kevin Phillips had written about the emerging Republican majority, it is true that the Electoral College is kind of stacked in favor of the rural states, that they would have a kind of persistent hold on the White House. Hasn't quite turned out that way. But I think that's what's happening, that, given the ambitions that a President Trump has for, I would say, incapacitating government, he doesn't really have a statute to rely on. Now, having said that, there's an awful lot of the Trump, if you could somehow detach his policy agenda from his rhetoric and his style of government and just say, okay, I want to achieve these things. Are there statutes that I can interpret that would help me? He could do a lot of things within the realm of conventional administrative law. They wouldn't be, the kind of shake, rattle, and roll kind of impact on the public consciousness, but he could get a lot done. But it's he wants to have a government in which what he says is the law. Article 2, he said during the first administration, allows him to do whatever he wants. I think he believes that. It's not far off from what his lawyers are probably telling him. And to do that, he has to argue for theories of presidential authority under Article 2 that are much broader than the court has ever signed on to.
It's easy to get your lawyers to tell you have total power when you only hire the kind of lawyers who are going to tell you that.
Right. That's the qualification. Right.
But I also want to say this is not, I think there is a certain point to this idea that, if you're FDR and you're trying to create the administrative state from the beginning, you're going to be a champion of doing lots of things with executive power. Right. Because you're trying to go farther than Congress has so far, mostly, for the most part, authorized you to, or you're trying to take new powers given you by Congress and push them as far as you can. Whereas if you're then trying to, coming along later and you're wanting to try to dismantle or remove big government and doing so against a long history of statutory, of congressional, of legislation that's been passed, then you're going to want executive power to undo it. But this has also been a bipartisan thing because for example, I noticed, I remember back during the Obama administration, he had there was a sort of controversy, a lesser controversy, but a controversy over his use of so-called czars, where he sort of grew impatient again with the cabinet system, with the principal officers, and would appoint a czar to be in charge of something. And that person was somebody who was not appointed as a principal officer, not approved by Congress, someone assigned by him to do a task. And it was sort of seen, at least among some critics, including myself, as an attempt to sort of do an end run around the cabinet system to not have to do things through the cabinet officers, but do things through somebody who was answerable only to the president and not subject to approval by Congress. So there has been a sort of bipartisan push over a period of decades to expand that sort of presidential power and make a more imperial presidency.
Well, the trajectory of presidential power has only moved upward since the 1930s. It accelerates at different rates under different presidents, to be sure. And it's some level, this can get complicated. I mean, some of the people called czars, they actually hold statutory offices. The so-called drug czar is, a statutory office holder. What these people are doing formally, whether it's for the Obama administration or under the Reagan administration or any administration, is they're trying to coordinate what people are doing and make sure that they are apprised of the preferences of the White House in making policy. And again, this has some centralizing impacts, to be sure. But it is important to note that the czars who do not hold statutory offices don't actually have decision-making authority. They don't have their own budgets. So a lot of this is going to be done by persuasion and meeting and coordination of that kind. I do think you can. Jack Goldsmith, who is Harvard law professor, he was head of the Office of Legal Counsel for some time under the George W. Bush administration. He's now, he does a very fine, you can find his work on a couple of blogs, but the most recent effort is something called Executive Functions that he does with a guy named Bob Bauer, who was Obama's White House counsel. So it's a bipartisan thing. And Jack had a good column, a very interesting column in the Times last week, I think, where he pointed out, various kind of individual things that you could find that administrations have done going way back that are sort of stretching what presidents are supposed to do with regard to either executing the laws or not executing the laws. And, again, there's a lot of nuance that would accompany any of these examples, I'm sure. But his point is, generally well taken. It's just that, and this I think is also his point, that the scope and volume of this obliviousness towards law is unique to the Trump administration. Yes, can you find, so Trump on the first day in office says, I'm not enforcing the TikTok ban. Well, you can find the Obama administration not enforcing some aspects of the Affordable Care Act immediately with regard to employers, I think, because they thought, it just wasn't right to hammer them too quickly. And you can say, okay, so see, each administration has done this. But again, you have to scratch your head to remember, what are the one or two times the Obama administration did this in 8 years, as opposed to what did Trump do yesterday or since lunch to come up, with a comparable example. And it is the scope and volume that is so threatening. And, you mentioned that Humphrey's executor, was seen as the conservative answer. But again, Cardozo and Brandeis were on board. And when Roosevelt, frankly, when he put forward the proposal to kind of stack the Supreme Court, a lot of the pushback came from his own party in Congress. And this goes back to this sort of very fundamental idea that Madison wrote about in the Federalist, which is, the Constitution is just paper, parchment is what he said. And for checks and balances to work, ambition must be used to counteract ambition. So you need a Congress as protective of its role, as the president is protective of his role, in order to have this kind of creative tyranny-resisting tension between them. So that's sort of what's disappeared. When President Trump, is making these moves, whether people are, whether maybe they agree with him, or maybe they're afraid of, the power of his endorsement in a primary campaign, or where Elon Musk is going to put his money in the primary campaign, whatever it is, he is all but effectively silenced Congress as, the counterweight to the presidency. And you could argue that, for example, with regard to war power, that Congress has been AWOL for a long time. A lot of our counterterrorism efforts are still based, and I put the word based in quotes, on the 2001 authorization to use military force against Al Qaeda. I mean, a lot of the people we're fighting were not born in 2001. What's Congress doing?
Right. Well, that leads, I think, what a good issue to end on, which is there's this problem of constitutional interpretation that, when we talk about Humphrey's executor and this way of creating these regulatory agencies where we put the power in a certain place and we have the role for the president and a role for the legislature and we're deciding how the courts fit into it. I've heard someone describe this as a constitutional settlement, right? So it's not so much that it's, the founders didn't say, here's what to do about the FCC, because there was no FCC or the FTC or
Right.
the antitrust laws. They didn't say what to do about it. That when these things come into existence, that there is a constitutional settlement that's reached where people sort of say they by case figuring out how to do this, with Humphrey's executor being one of those cases, that we reach a sort of a legal or constitutional consensus or settlement on this. But it's a matter of interpretation that's been adopted by usage and custom and sort of brought forward. And that always creates a problem of constitutional interpretation, that it's not written down in black and white. You have to understand the spirit of it, the spirit behind it, and the ideas behind it, and have us preserving that in the decisions we make today. But not necessarily being able to say this is all settled. If it were all settled in black and white, it probably wouldn't be going to court.
Right. So John Marshall, the first great Chief Justice, referred to the Constitution as a document intended to age for intended to endure for ages to come and to be adapted to the great crises of human affairs. And I, you know, the phrase "living constitution" has become kind of a bit of a cliche. I actually, although it's a little wonkier, I actually like to, as a tribute to Chief Justice Marshall, call myself an adaptive constitutionalist, because I think that's the most honest way of approaching the Constitution. The advertisement for what's called originalism, and believe me, we could do another hour or a full semester seminar on originalism. But the promise is that somehow this is more objective, that by confining our attention not to the policy impacts of today, but what the historical materials tell you about 1789, that somehow we could trust judges to be more objective and less partisan, less politically motivated. It simply doesn't bear out in practice, and sadly, I'm pretty tolerant of the imperfections of human nature, being of that sort myself. But occasionally you will see the Supreme Court, which purports to be following the original design, say things that are just preposterous as interpretations of history. And one of them, which I just found staggering, in Sealer law, this is the case that said, the presidency is guaranteed this removal power over single-headed agencies. John Roberts wrote, I swear I'm not making this up, that the framers created the president to be the most democratically accountable officer in the new government. That would be the exact opposite of what the framers decided. Only the House of Representatives was directly accountable to the voters. The Senate was chosen by state legislatures. Okay, you could say state legislatures were at least voted on by the public. The president was chosen by electors who would be chosen by the state legislatures if they wanted, or the state legislatures could and eventually did leave it up to the voters. But he's like 3 times removed from democratic accountability. And I keep mentioning Jed Sugarman as a historian, because I just think his work in this has been so good. He points out that even the choice of the word president in 1789 is interesting. That the people who were the chief executives of the states were called governors. The Continental Congress, that period of time, there was a president of the United States, and what the president did was presided. That's what presidents did. They just presided. And so the whole idea of, this person being something other than the person making sure that the laws get carried out has evolved into something very different. And arguing about what it means today as if we're arguing about 1789, instead of arguing about how to match the language of the Constitution to what is most appropriate given the democratic needs of 2025, I think it's just not candid. It's just a kind of self-delusion.
Yeah, my disappointment with originalism is it turned out to be just the rules of a word game for how you figure out to do what you really want to do, from your own ideological perspective, by coming up with the right words to say that it's original, but you're really not going by something that's original. You're going by something that you want. But maybe the solution is we need to amend the Constitution more. So I'm going to end by, this is the thing I'm going to start asking everybody, which is, in light of recent events, in light of weaknesses in our constitutional system that have been revealed, I guess, what constitutional amendment would you propose if you were to change the Constitution? Because instead of arguing about what's happening in 1789, we can change it. We can put something new in there. What would you put in that would be new?
So I think what has to change, I don't think it would work to, there are lots of sessions. I'm rambling. There are lots of things I'd like to see in the Constitution. I'd like to get rid of the Electoral College, for example. I'd love to see a Senate apportioned by population, not two people from Wyoming and two people from California. But having said that, I think the main point here is uh, passing a single thing that says, when we say due process of law, we really mean it, or we really want lots of freedom. That's not going to be enough. There has to be something to affect the way politics is done and the way people in office are responsive or not responsive to voters. And so, way back in 2011, I offered a draft of a constitutional amendment, which I published in something that was then called Huffington Post, not just HuffPost. And it didn't exactly take off. But the idea was to incorporate in a constitutional amendment a number of reforms that would make things more democratically accountable to the people. For one thing, it would make voting a federal constitutional right. It wouldn't be left up to the states to determine the scope of voting rights. It would be a federally guaranteed right, and it could only be limited by the states under a test like what we call strict scrutiny. If there was a compelling governmental interest, it could only be served by a certain mechanism. So you wouldn't have states being able to say we don't have mail-in voting, or no more drop boxes, or everything has to be counted on the day of the election. These are absurd things. It would authorize the regulation of campaign finance as long as it was done in a viewpoint neutral way. And it would, again, this is the Shane Amendment, it would guarantee the rights of voters to vote if they're voting in districted elections, like Congress votes in districts, state legislatures are divided by districts. They have to be, voters should have a right not to be voting in districts that have been drawn substantially for the purpose of killing political opposition. That's what gerrymandering is. So the good news, again in quotes, is that apparently, as of this moment, it's a very unstable situation, that there is as much gerrymandering on both sides for the Democrats and the Republicans as the other side has. So if you have as much chance now of being a disenfranchised Republican voter in a safe Democratic district as you do of being a disenfranchised Democratic voter in a safe Republican district. But this is crazy. It means that the people representing those districts don't have to worry about your vote. And as a result, you get, if I may say, a Marjorie Taylor Greene representing, a district in Georgia. She's clearly going to be to the right of even Republican conservatives in that district, because she's going to win the primary, and then no Democrat's going to be able to win that seat. So I think, and again, this is wishful thinking, but if you could somehow have a pro-democracy constitutional amendment that allowed for the reasonable regulation of campaign finance, made voting a federal right that could be restricted by the states only in very, very limited conditions, and would guarantee people really a right to vote in competitively drawn districts, that would have a profound impact on the nature of our democracy.
Well, that's an interesting proposal. Now, the interesting thing about that is because I'm somebody who's been against campaign finance reform, because I noticed in your proposed amendment, because I took a look at this beforehand, that you have a thing saying that none of this can be implemented in a way that that would be basically be partisan, or would be attempt to suppress somebody for their political views. And what I see from what's happening right now is how ineffective those provisos are. If somebody really wants to implement, if an executive really wants to implement something in a partisan way, he's going to do it. So I guess the philosophical difference here, and maybe this is sort of philosophical difference between the small government and bigger government, the traditional 20th century liberalism, is my thing would be saying, let's take more power away from government, rather than trying to find new ways to limit, to try to put more guarantees that that power won't be abused. Let's not give the power in the first place. But I think again, that's a conversation for like a whole other session about the proper balance of the amount of power government has. But I really want to appreciate your offering that proposal. I guess I'm asking everybody about that because I think it's time to consider those what we could change about our system, how we could reform it. And I want to thank you for taking time to explain this issue and to discuss the history of this.
Rob, I really appreciate your interest. You gave me great help in editing the piece that was published in the Unpopulist, and you know, I don't know if this is a silver lining or not, but if there is a silver lining to what we're going through, we're really seeing an uptick in publicly accessible civics education.
All right, that's yeah, I really appreciate that. Thanks so much for talking to me.
You're very welcome. Thanks for having me.
I'm Rob Tracinski with Symposium. My guest today has been Peter Shane, Distinguished Scholar in Residence at NYU. Please like or subscribe to this podcast or to this channel on YouTube. And for more information and analysis on the foundations of a free society, go to symposium.substack.com. Thank you for listening.